talk about it, the Bouarfa v. Mayorkas et al. Decision, and that is kind of the segue is we are going to fight again under this administration, but there's a different Supreme Court, and Patel has now been issued, and the talk of, not the talk, the theme of the Supreme Court, I suppose, over the last 4 or 5 years in immigration has been limiting jurisdiction of federal courts to entertain anything. Wilkinson's a bit of an outlier, but even that is deferential review. And here we have Bouarfa relying on INA Section 242A2 to prevent review of USCIS's decision to revoke an I-130 petition for any basis, in this case based on a subsequent 204C finding. So Miss Bouarfa had an I-130 approved for her husband, and then later USCIS decided that that husband had attempted to engage in marriage fraud, or maybe had engaged in marriage fraud previously, and they revoked the approved I-130 petition. Now, the question was whether or not Ms. Bouarfa could then sue in federal court, because they were, of course, strenuously arguing that there was no prior marriage fraud. I don't know if there was or was not. There are no facts developed. Now, it's interesting. 204C is mandatory. If they find marriage fraud, actually, I don't want to get this wrong. Is 204C? Yes. 204C is mandatory, I believe. If they're adjudicating an I-130 and there is, marriage fraud that occurred, they shall deny it. And so if it's mandatory, the argument is it's not discretionary. And so even the Solicitor General in Bouarfa and the Supreme Court very much seems to have blessed that an I-130 denial based on a 204C finding is reviewable in federal court, because 204C is mandatory, and on the other hand, an I-130 approval is mandatory if they, meet the qualifications. But the decision to revoke an I-130, or really an I-140 petition, and by the way, I think there was a First Circuit decision or maybe an Eighth Circuit decision a few weeks later applying this principle to the I-140 context. It's the same petition revocation statute. I want to get the language correct, exactly correct, because it's very important for this. USCIS may at any time for what the Attorney General or the Secretary of DHS may at any time for what he deems to be good and sufficient cause revoke the approval of any petition. Supreme Court said because that's discretionary, even though a 204C finding is mandatory, because that's discretionary, there is no review. Because INA Section 242A2Bii, and kind of as interpreted broadly with Patel, serves to bar all discretionary decisions by the government, which is, it's a wild thing.
Yeah.
Because again, this exact issue, the 204C in connection with an I-130, is reviewable, but USCIS can insulate itself from review if they decide to approve and then revoke. Pretty wild, right?
Yeah, it's a ridiculous decision. It just puts people in just rescission and revocation are just like so annoying.
It's a ridiculous decision. It's a unanimous decision. Unanimous, no dissent, no concurrence. But that's because, well, I have no idea why, but Justices Sotomayor, Kagan, and Jackson have made very clear that they respect stare decisis, and the holding in this case does follow decisions like Patel and Gerardo Lasprilla and Wilkinson, all of that. So I'm not saying it was required, but it's not astonishing. We filed an amicus in this on behalf of what this would do to revocations of, say, an I-140 petition in the EB-5 context, or maybe not the EB-5 context, but EB-5 petitions. I mean, any petition is potentially at play and unreviewable. And that, in the employment categories, there's hundreds of thousands, if not millions of dollars at issue in federal court. It's pretty wild.
How do you deal with it then? Like, you do a BIA appeal on an I-130 that's been revoked, or just file a new one, have that denied, and then appeal that?
Well, it's both. So you can absolutely, as happened here, file a BIA appeal. It's just once the BIA denies, you have federal court redress, because they're not going to put you in removal proceedings, or if they can, that you can get no redress on the petition and removal proceedings, because only USCIS, as you know, can approve or deny such things. But yes, as the Supreme Court indicates here, Ms. Bouarfa filed a new I-130 petition. USCIS will deny it with the 204C finding, and then she can challenge that at the BIA and then challenge that in federal court.